Call Andrew Maternowski.
Witness sworn.
Please state and spell your name.
First name is Andrew, middle initial C, as in Charles, last name is Maternowski, Matrnowski.
Are you a criminal defense lawyer?
Yes, I am.
How long?
I'm in my 35th year.
And where'd you go to law school?
I went to IU Indy.
And what was your practice after? Oh, when did you get admitted?
1989, fall of '89.
And what was your practice after that?
When I was in law school, I did a certified legal externship I guess is what you'd call it with the Marion County Public Defender Agency. At that time, during my summer job, I was also working for a private attorney in Indianapolis doing criminal defense. When I finished school, I think the day I got sworn in I did a hearing that afternoon in Marion County and have spent 17 years working with that attorney, doing almost nothing but criminal defense. Then I moved out of his building into another building for 10 years, doing almost.
Approximately how many court trials and jury trials have you had?
Court trials, I have no idea. Jury trials, 35 to 50. I've never kept track of numbers like that or caseload or anything like that.
How many different jurisdictions?
I've practiced throughout the state of Indiana. We have 92 counties. I think I've counted up, I've practiced in over 80 of them, probably juries in 20 to 15 to 20, maybe 25 different counties. I've done stuff in federal court in the Northern District of Indiana, the Southern District of Indiana, I think it's the Eastern District of Tennessee a jury trial, and then a jury trial in Missouri, a jury trial in, not a jury trial, a criminal case in San Antonio, Texas, in federal court.
And in your trial preparation, would you consult with both attorneys and non-attorneys?
Yes.
And would you share with them the expected evidence?
I would.
For those trials?
I would.
Why do you do that?
To get a better perspective. I found that when I'm preparing for a trial, because I'm looking in my client's best perspective on how are we going to try this case and win this case, the term I've used is, breathing your own fumes, when you think you have a great theory of the case, theme, a great approach to how.
You've heard me discuss with the other attorneys about a war room?
Yes, sir.
What's your definition of a war room?
Essentially, a conference room where everything is spread out. A lot of younger attorneys today can do everything on a phone or an iPad or a tablet or a laptop. I can't. I have to have printed pieces of paper spread out everywhere. When I start preparing my case, I make copies of almost everything and then I made a copy with color-coded pens, where I do all my notes, and I need a copy of that to be able to pick up and look and hold and then pick another piece up and look and hold and say, okay, here's what witness has said, here's what witness B said. I can't do that on a computer, so what I do is we have a conference room on the 3rd floor and a conference room on the 1st floor. I'm in an old house on the north side of Indianapolis, and there's a big table up on the 3rd floor and there's a big table on the 1st floor, and I would spread things out all over both of those tables, depending on which one I start using first.
Have you ever received a misdirected email?
I have. I've received many over the course of time, one from a prosecutor when he and I were discussing a deposition, and when I received it, I sent it back to the prosecutor and said, this was not meant for me.
Was it apparent from the email that he was intending to send that to a police officer?
Yes. We were in the middle of talking about a suppression issue and trying.
And have you attended CLEs where brainstorming was addressed or taught?
I've both attended and taught at seminars.
Tell us a little bit about your teaching.
Okay. For 22 years, I've been on the faculty of the Trial Practice Institute. It's an annual program put on by the State Public Defender Council where we break down cases into small groups and you start with brainstorming and you start with, then move into voir dire techniques and direct exam, cross-exam, opening statement, closing, and you, essentially, when you're in the brainstorming part of the case, everybody, We used to work from a set fact pattern. There's a fake case out there where there's some allegations against the person at two different crime scenes and everybody worked from the same fact pattern. About 15 years ago, we shifted to a bring-your-own-case format, where every participant, these are public defenders and private defense attorneys from throughout the state, would bring their discovery and bring their cases with them. We found it more helpful to do real facts and real cases that people were really going to be trying in the future.
And you've described your war room as being separate from your private office?
Yes.
And would you expect to be betrayed by a friend or former associate that comes to visit you in your private office but, unknown to you, goes into your war room and takes pictures of the stuff in it?
I would not.
Would you feel any need to put up protections against such a thing?
No.
You would not anticipate such a thing happening?
Oh, the location where the war room would be set up and everything would be spread out would not be in a location where I would expect anybody.
Well, from the general public, but what if they were a friend or a former associate and had come to where your office is and found you unavailable? Would they be passing like the first-floor war room?
In order to get to where my separate office is, they would go alongside where that war room is.
So they could go in there and take pictures without your knowledge?
Yes.
And you would not expect you would suffer such a betrayal?
I would not.
That's all I have.
Mr. McClelland.
Mr., can you say your last name for me one more time? I apologize.
That's all right. Maternowski.
Maternowski, okay.
It's a lot simpler than people try to make it.
Thank you, sir. Good afternoon.
Good afternoon.
I want to talk about some emails first. Well, let's back up. Have you ever been subject to a gag order?
I have.
In a case? And have you ever been subject to a protective order?
Yes.
And you had talked about if you inadvertently sent an email to somebody. If you'd inadvertently sent an email to a civilian in violation of a gag order, would that...
I'm gonna eject. Assumes facts not in evidence. A misdirected email was not a violation of the gag order. That's a legal conclusion for this court to make. Now, if he wants to say, ask the question, did you ever send an accidentally misdirected email that had an outline of your discovery organization that would fit the evidence so far?
Would you like to finish your question before I rule on his objection?
Sure. Judge, I'd like to respond to the objection too. But let me see if I can phrase it the same way, Judge. If you sent an email to a civilian in violation of a gag order, is that something that you would feel that you need to make the court aware of?
It would depend on who that civilian was. If I just sent it to somebody random, yeah, I probably have 5,000 people in my contact list. If I misclicked on something and it went to somebody, I would probably notify them immediately.
And so let me make sure I got this correct. So if you sent an email that violated a gag order that was in place in your case, me aiming that email would have to have some information pertaining to the case or evidence pertaining to the case, you wouldn't feel it necessary to notify the court that, even inadvertently, if it was inadvertently, that you had done that?
I wouldn't notify the court at first. I'd probably notify, in a typical case for me, it would be the prosecutor. I would say to the prosecutor, hey, this is what happened. What do you want to do?
Okay, fair enough.
If they said we need to tell the judge, we'd tell the judge.
Fair enough. You had talked about oftentimes. Maybe not oftentimes. There's been times that you've had cases and you've run the information by your sisters or sister to get their take on the presentation of your case.
Yes.
Is that?
I've got.
Okay, go ahead.
I've got a D felony or a level 6J jury of older sisters. I've got 7 older sisters, and they're all semi-professionals and they've got a lot of experience. I've got one sister who's a retired nurse, who I trust her opinion on medical things more than any doctor that I've had looked at autopsy photos, injuries, things like that.
And is that for you to be able to get someone from the public their opinion on the strength or weaknesses of your case?
With that particular sister, no, that's usually for more of an expert opinion, but I've done similar things with other people, other civilians, other family members, other attorneys, friends.
And again, is that to determine the strength and weaknesses of your case as they see it?
Yes.
Okay. And so is it fair to say that with the evolution of the internet and the evolution of social media that an attorney Sewell also used social media and the internet as a way to push out the facts of the IR case to gauge the public response?
You could, yes.
Okay.
I'm not sure how useful that would be if you're not getting any feedback.
I don't have any other questions, Judge. Thank you.
No redirect. Thank you.
All right. Thank you.
May he be excused.
Thank you, sir. You may step down.